And please record. I'm Jack Aiello. I represent Jeffrey Meehan and HG 51. I'd like to reserve 5 minutes of time. Charles Funk and Jeffrey Meehan were 27-year partners. They operated a number of companies together, usually under the same kind of an operating agreement. The company at issue here is HG 51. There were 2 different classes of members in this closely held LLC. Class A members were the controlling members, that was Mr. Funk and Mr. Meehan, and Class B members who were investors. And in this company, that was essentially their families. It was a family-owned, 2 family-owned, closely held company. This agreement, the operating agreement, and part of it that's relevant is Article 10. It's the part that deals with transfers of interest. Section 10.1, the very first section of Article 10, is the heart of this agreement, the heart of transfers. And it is the main and only protection that each of the members have with respect to who runs the company. It's their voice. If a member tries to transfer their interest, 10.1 requires that they get the approval of the members appropriate for that kind of membership. Class A member, to transfer their interest, must have the approval of all of the other members. That has teeth, because that means that any member who doesn't like or doesn't believe in a potential new controlling member can stop it. That's powerful. As to a Class B member transferring their interest, the Class A members would have to approve it. That's a powerful provision, and there's a sentence in section 10.1 that explains it, explains why that is. It says, all members acknowledge the reasonableness of this restriction in view of the purposes of the company and the relationship of the members. Section 10.1 does no less than preserve intact this closely held family-owned company, unless everybody agrees to something else. It goes on. The second paragraph of 10.1 has teeth. It says, where anyone tries to transfer without complying with this provision, the transfer is invalid, null, and void. That person can't vote for the company or act or participate in management. This provision is serious about protecting the rights of the members. That's the heart of it. Section 10.11, that's the section that the trial court interpreted. That's the last section in Article 10. And it just deals with one situation, where a member dies. Where a member dies, Section 10.11 provides that that member can pass their financial interest, which is a financial asset in their estate. That makes sense. If the member tried to pass that interest when they were alive, they'd have to get the approval of the members. But this concession under 10.11 makes sense, because if the person dies and still needed to get the approval of the members, if the members rejected that transfer, what would happen to that financial interest? The deceased member is not around to try to transfer to someone else or negotiate. So 10.11 deals with that practical problem of transfer of the financial interest. But if the recipient of that financial interest seeks to become a control member, then they have to comply with 10.1. Section 10.11 accomplishes that by saying, provided, however, if you seek to acquire the control interest, you have to comply with 10.7, which incorporates 10.1. So that makes sense. That is a construction that's in harmony with the purpose of this whole Article 10 on transfers of memberships and protecting their interests. What the trial court did wrong, we really could break it down into 2 mistakes. And those 2 mistakes are highlighted by the law that the trial court cited. The court cited very little law in its order. It cited a case from this court for the accepted proposition that the court should try to interpret the provisions in a way that gives effect to each provision and harmonizes with the rest of the agreement. Unfortunately, the trial judge missed on both. The court concluded that Section 10.11 doesn't have a valid purpose unless the purpose is to also automatically transfer the controlling interest or voting interest of the dying member. And the judge missed that. I think for whatever reason, the judge didn't understand that Section 10.11 does provide a benefit. It allows the transfer of that financial interest, the financial asset, without getting the approval of the members. That's a logical and useful purpose of Section 10.11. The judge just missed it.
So control is not transfer.
Absolutely not.
the ability to make financial decisions for the companies not transferred.
Not transferred.
So when Carol Funk was identified as a manager and was instrumental in getting a $17 million loan, and Mr. Meehan signed this document that had Carol Funk and his representative, and he stated Charlie B. Funk, Class A member, and she's referred to as a manager who can execute documents and take other actions that may be required on behalf of the company. Does that not waive it?
Does it waive it?
Really?
No, does it?
$17 million, so Mr. Mann can still operate his company. He refers to as her manager.
Right.
She can make all the decisions that he can. He signs a document with it. It means nothing. She only has a financial interest in the company. She cannot control what happens, day-to-day operations.
She has a huge financial interest in the company, and that gives her incentive to sign a guarantee.
Senate?
Sure.
No. He called her a manager.
Well, that's what they say. He didn't call
No,
her.
that's what he says in the document he signed.
Well, he didn't prepare that document. We don't
It
even.
doesn't matter.
We don't-
He signed it.
Okay, but that doesn't mean that he approved her being a control manager,
Oh, okay.
right? And also, it doesn't
So this
speak,
document doesn't mean
it means that someone guaranteed a loan. That's all it means. The other member, he can't speak for the other members. Now, the issue you're raising is, did Mr. Meehan waive his right to vote against her if she put to the members her hope to be a controlling member? That's a fact question. You know, a waiver has to be knowing and voluntary. Maybe a court would conclude that that wasn't knowing and voluntary.
She was treated as a substituted Class A member.
When you
Carol
say,
Funk was treated as a substituted Class A member.
not by the members, I don't know what you mean by treated by. I mean, there was a label on the paper she signed that said Class A member, and she wasn't a Class A member anyway.
then why'd you sign it?
She owned 40-some% of the company, and
That's
if
your
they,
response.
and if
That's why
they,
she signed it.
and if they don't get the loan, their business fails. So that's,
Your client's business fails too.
that's true.
So that seems to be controlled.
Well, that seems to be making a good financial decision. We can't assume that that means,
For the town homes and all that,
yeah, for whatever the project
around
is.
here somewhere?
I don't know exactly where to go. Yeah. So, but Mr. Meehan can't bind the other members anyway. Let's assume that he was waiving his right to oppose her being a controlling member. That doesn't speak for the other members. Section 10.1 is the heart of the members' ability to have a say in who runs the company, whether they believe in who runs the company. Nothing Mr. Meehan does affects the other members' choice in that matter. Right? So, I mean, the first question is, does 10.11 automatically convey control interest? That's a frivolous interpretation. In fact, 10.11 conveys that financial interest even by intestacy. So for the judge to have been right about that, the members would have had to been agreeing that, yes, we care very much about who becomes a transferee, who can transfer their interest, we want to have that vote. But if somebody dies, then we don't care anymore, and even through intestacy, whoever the law says is their closest relative can be our new controlling partner. That is a ridiculous interpretation. So the judge failed to see that 10.11's purpose is a valid one to allow the conveyance of the financial interest. His interpretation was not in harmony with the rest of the agreement, right? Harmony with the rest of the agreement would preserve the rights of the members to have a voice in who is running the company. The issue you've raised is something they've written about in the brief. Mr. Meehan acknowledged that she was a controlling member by letting her sign a guarantee. She signed it individually. We have no idea why she signed it. And keep in mind, she wasn't the person to whom the property was left in her husband's will. It was a trust, right? It was the Charles Funk Trust. The Charles Funk Trust didn't guarantee this loan. Carol Funk did. She can't just skip through the trust and say, I'm a controlling member. How could she do that? Right? She's not even the person to whom the will left the property. So that argument fails for important technical reasons. She isn't the beneficiary. So anyway, that's their secondary argument, and really they make that to say even if we're right that the court may, the court's wrong in their interpretation, Mr. Meehan approved her being a control member. This is bypass all the rules, bypass all the other members, and make her a control member because she signed this guarantee. Keep in mind the control members, their financial interest as a Class A member is only 0.5%. The main financial benefits of this property and this company are paid to the Class B members, who have 99% of the financial interest of the company, 99%, and she had half of it. So she had every incentive to sign a guarantee. But I don't think that's a point we really need to debate here today, because there's no way Mr. Meehan could bind the other members. She still would have to have their approval. The only way she could be a control member is to have the approval of all the other members. The only way the trust could become a control member is if the judge was right that section 10.11 just tramples over 10.1 and allows a transfer of a control interest by will. The will here was dated 2005. The company was formed in 2011. Mr. Funk didn't designate someone to become his control transfer. He didn't designate it as a control. In fact, there isn't a word or a phrase or a sentence or a document anywhere in this record before Mr. Funk's death that shows that anybody thought that section 10.11 transfers control interest. Nobody said that. Nobody thought that. And even after Mr. Funk died, even the plaintiffs didn't think that. They sent 2 proposed amendments to Mr. Meehan to try to add a Class A member, and he did not agree. It was a year and a half after that, more than a year and a half after Mr. Funk's death, that for the first time they took the position that section 10.11 actually transferred his control interest. That's it. It took that long, and that's when the lawsuit started. If you have no other questions at this point, I will reserve the rest of my time.
All right, you have 5 minutes, sir. Thank you.
Thank you.
Good morning.
May it please the court, good morning, Your Honors. Chance Lyman on behalf of the appellees here. Your Honors, this case is about treating death different. The trial court correctly interpreted the entire context of this operating agreement to arrive at the only reasonable interpretation of Article 10, the transfer provisions. Specifically, that is notwithstanding 10.1's general unanimous consent prohibition, and I want to emphasize the word prohibition, the agreement will not prohibit the transfer upon death, the automatic transfer upon death of the percentage interest. Now, once the percentage interest is transferred, 10.11 tells us just go comply with the ministerial conditions of 10.7 to become a substitute member. That is it. That is eminently reasonable.
You're saying this happens by operation of law?
That's correct, Your Honor.
Strictly by operation of law?
That's what 10.11 tells
He's
us.
saying it's forbidden by the language of the document.
Yes, that's correct, Your Honor. But 10.11 tells us the transfer happens automatically and it's not prohibited.
And that's not inconsistent with the other provisions.
Not at all. Of course, we have the word notwithstanding. It's pretty much the most essential, drafter's indicator that I'm about to tell you something different.
No, I'm listening.
Okay, yeah, notwithstanding always tells us, I know I just told you something, I'm about to tell you something different. This word's going to rationalize why these 2 provisions are going to be read in harmony, and that's exactly what the trial court did here. I mean, I don't even think case law is really essential to this determination, but the best case here, I think, is really the White case from this court. It really touches every single one of these points. If 10.11 still required unanimous consent, it would have said it. It doesn't say it. It says the opposite. It removes the prohibition. That's the first thing 10.11 does
So
to
the only thing I'm equivalent with, you said death was different, but it seems to me the contract is different here. The contract controls regardless of the death provision. And that's what, isn't that what you're arguing? The contract's consistent, it's not inconsistent, controls the transfer, then we don't care about the death.
I agree that the contract is not inconsistent because it's talking about the same transfer of the same percentage interest in 2 mutually exclusive factual scenarios. So what it does is it tells, like the trial court said in its order, the trial court's process was to go to the table of contents first, figure out where am I going to start my interpretation of this agreement. Well, you started at the death of a member because that's what happened. That takes us first, sort of chronologically, to 10.11. If you follow that reasoning, which is really the only reasonable interpretation of all of Article 10 together, it tells us, well, it's not going to prohibit the transfer of a percentage interest that happens automatically at the time of death.
But what the appellant is arguing is there's a difference between percentage interest and a control interest. Is there?
Here's the difference.
Because it's percentage interest capitalized.
Yes, exactly, Ron. I agree. Here's the difference. Percentage interest versus substitute membership. That's the difference. Now, that tells us, really what this is, it's really self-contained in 10.11. 10.11 deals with both of those topics. First topic is transfer of a percentage interest. Again, that's why it's critical that that 10.1 tells us it can happen automatically at the time of death.
But Class A percentage interest. 10.1
Yes,
talks about Class A percentage interest.
talks about both classes of
Does that
percentage.
include financial and control when it refers to Class A?
Yeah, yes, Your Honor. Any and all rights is the language that we find in both 10.1 and 10.11. Any and all aspect of the percentage interest. I think it's critical that 10.11 and 10.7, those are different subject matters. That's another reason that this is a totally harmonious reading of the agreement that's giving effect to all of the language. The percentage interest transfer, you can look at 10.1 if you're doing it during life, or you can look at 10.11 when it happens automatically at the time of death. That's the percentage interest transfer language. Now, 10.7 is how do I then become a substitute member? So what does 10.11 actually tell us about 10.7? I think that's what's critical. 10.11 tells us here, in order to become a substitute member, after the transfer's already happened, become a substitute member. Well, look back at 10.7. Here's what 10.7 says. An assignee may become a substitute member if all the following conditions are satisfied, A, B, and C. No one's debating that A, B, and C was or wasn't satisfied today, so that's not really an issue in the court. The only thing that the debate is now centering on is 10.7 mentioning validly assigned under 10.1. Well, there are a few textual clues that tell us that doesn't mean I have to comply with the unanimous consent prohibition. The first textual clue is 10.7 has nothing to do with transferring a percentage interest. It's a totally different subject matter. The second clue is validly assigned is in the past tense because the transfer already happened. And the third clue really just takes us back to why is the word notwithstanding in the beginning of 10.11? It's there to address the exact debate we're having now. Ironically, it was supposed to make it a bit simpler. It lets us know that we don't have to validly assign something under 10.1 to the extent that means comply with the unanimous consent prohibition, because notwithstanding that prohibition, this agreement is not going to prohibit a transfer of a percentage interest automatically at the time of death. I'm emphasizing the word prohibit because, as my opponent just stated, there's a sentence at the end of the first full paragraph of 10.1. It's the purpose sentence. Each member hereby acknowledges the reasonableness of this prohibition in view of the purposes of the company. The prohibition is what they're talking about there. 10.1 tells us the agreement will not prohibit the automatic transfer at the time of death. I just want to take a step back from here. Philosophically, the approach to interpreting a contract, you need to read the language first. I feel as though the initial brief has presented, they've skipped to the step of asking whether something is or isn't reasonable. The first thing any court, any party, anybody has to do when they're asked this question is, what's the language say? That's the end of the case right here, because the language very clearly, unambiguously says the unanimous consent prohibition, which is the only complaint that the appellant's raising right now, it just doesn't apply, period, end of story. It's a more specific, it controls over the general. I don't really have too many other points. I will point out to the court that there is an example, if this court needs one, of when members do want to reincorporate that compliance or re-solidify it, 10.2 is a great example. Talks about a transfer, a right of first refusal, and it says you can do so only in full compliance with the provisions of 10.1. That's not contained in 10.11 at all. That's why I referenced this court's White decision. It addresses that. If the parties wanted to reincorporate that, they certainly could have done so, and they didn't do so here. I heard my opponent say that, Charles Funk never expressed an intent to designate a new Class A member. Well, that's why this agreement has 10.8. 10.8 tells us that in the event of a death, obviously that member can no longer express that intent. That's exactly why 10.8 now says the personal representative has that power to express that intent. So again, perfectly harmonious, completely rational. Judge Lee, you asked a few questions about the estoppel issue. It's not just a guarantee that was signed, and I think that that's critical. At the appellant's appendix, page 140, we see that written consent and joinder document. That's a document where, above the signature lines, I want to emphasize, there's a statement that says we are all agreeing that these Class A members are going to engage in this written consent, and that's a document separate from the guarantee that shows that there should be an estoppel here now. And as to that point about, we haven't estopped Class B members or things of that nature, that's, I think, a fundamental misunderstanding of what the legal doctrine of estoppel is. It's an affirmative defense based in equity. It really only applies to the litigant who's trying to take the inconsistent position. There's no evidence in this record that anybody
What is the
else.
significance of the trust initially trying to obtain Mr. McMeehan's consent?
I'm really not sure what the significance of that event is. It's not something that is required by the operating agreement, and obviously the documentation that comes later makes that pretty clear. I believe the first, fact circumstance highlighted by the appellant here is an attempt to actually rewrite a lot more than just, becoming a new Class A member, and that was.
Voided out 10.8, right?
Sorry about that.
I would have voided out section 10.8. Had there been a signature forthcoming that wasn't necessary. You're hanging your hat on 10.8.
To the extent that we needed to comply with that, 10.8 kind of tells us how to express the decedent's intent. That's because 10.7a talks about the decedent's intent. So those sort of directly harmonize to each other. If there are no further questions, Your Honors.
No, sir.
Thank you very much.
Thank you. Yes, sir, you have 5 minutes.
Okay. Thank you, Judge. Go back to Judge Valente's comment. Death is different. It's not different.
A little bit louder.
Death is different, but it's not different to the remaining
It's
members.
not a death case.
It's not a
It's not a
death.
murder case.
Right.
What they're saying is we all have to be death qualified as judges, and they call the course of death is different.
Okay,
That didn't take a few times.
all right. So I assume that course was not about this case.
Yes.
Right. But the point is that somebody's death has nothing to do with running the company.
Well, this is the person's wife, it's the decedent's wife, right?
It's a trust, actually, and she may be a trustee in the trust.
She stepped in his shoes, right? Who stepped in the shoes of the decedent?
The trust,
The trust?
the Charles Fund Trust was the.
Controlled by the wife.
Yeah,
Okay.
the trust, yeah, and then she's a trustee or something, I don't know exactly, but there's another trustee.
Well, the trust is not even in the record. You guys don't care about the trust.
The trust is in the record.
Do you care about the trust, the contents of the trust?
Not necessarily. I mean, the point is, their argument is that the trust became the new controlling member, right? Because that was the beneficiary under the residuary clause of Mr. Funk's will. That's their argument. The point is that the protections of these members under 10.1, the thing that allows them to protect and preserve their interest in who's running the company, that's just as important if a member departs by death as it is if they depart by
This is a
retirement.
wildly successful business, correct?
I mean, I assume so. I haven't
Is
seen
it
it.
still wildly successful? We don't know.
Don't know. I don't think the record addresses that. But it's running. Presume it's an operating company. So the members have just the same interest in who's controlling the company if a member departs by death as they do if the member departs by retirement. There's no difference at all. Section 10.11 is not designed to change all of that and abandon the protections of the members to whatever the whims of the will or intestacy. That's it. Think about that. Section 10.1 says this financial interest transfers even by intestacy, right? Did the members really agree? We want to control who's running the company, but if a controlling member dies, and even if they don't have a will, whoever under the law has their property interest can be our new controlling partner. And it could have been 92-year-old Aunt Gertie from Canada, could be the new controlling partner under that the interpretation that the judge has adopted.
That's not really what happened, right?
No, but we shouldn't be result-oriented.
Joe Biden.
Right. But the two gentlemen that ran this company have 27 years experience doing commercial real estate development. Mrs. Funk or the Funk Trust doesn't have that. If the members thought she was capable or the trust was capable of being a controlling member, they can vote for that. But that shouldn't be shoved down their throat because of the happenstance that Mr. Funk died to transfer his interest rather than resigned and attempted to transfer his interest. It's undisputed. If he had just resigned and said, I can't do this anymore, I want to transfer my interest, the other members would vote on whether he can do that and designate someone to be a controlling member. Why did they lose that right? Because he just happened to die, right? That doesn't make sense. 10.11 does have a purpose, and it's an important purpose, and it's to pass that financial asset without having to get the approval that the dead person is going to have trouble getting. 10.8, by the way, all it does is authorize the PR to do what PRs do, to take the property into the estate and then pass it where it goes pursuant to the will. It doesn't give the PR the power to designate a new controlling member, right? It only gives them the power to designate, to distribute property. That's it. 10.7, which 10.11 says you must comply with if you want to be a substitute member, it incorporates 10.1 wisely. It says an interest transferred in accordance with 10.1 to be a substitute member, then you comply with the 3 conditions. When opposing counsel talks about it, they say that 10.11 says you only have to comply with the conditions of 10.7. It doesn't say that. 10.11 says you have to comply with the provisions of section 10.7. The first part of 10.7 is the most important provision. It has to have been approved by under 10.1. So if all you care about is receiving the financial asset from the departing member, and you're the beneficiary, the recipient, you're done. That's all you need to do. But if you want to become involved in the management of the company, you still have to undergo the requirements set forth in 10.1 in fairness to all of the other members. And at that level, if you're seeking that, you do need the approval of the other members. Nothing else makes sense. The law that we cited, in many cases by this court, in fact 4 cases authored by this panel right here, talk about that. Talk about you have to look at the purposes of the agreement and the intent of the parties when they entered into the agreement. 2 great Supreme Court cases apply directly here and talk about.
You're at 5 minutes.
Okay.
How about
All right, Judge. So I'm just pointing out the 2 Supreme Court cases have great language that is very helpful here. Florida statutes is consistent with our interpretation too. When a member dies, control dies with them. Thank you very much.
Thank you very much. Well argued. All right, we're going to forward our last case. Safe trip home.
Thank you.
Janet Rowland Burr.